Harry stunned after Judge Nicklin confirms 16.2M won't cover the bill, and the most terrifying detail is not the gigantic $34 million figure dominating the headlines, but the brutal warning buried inside the claimant's own court submissions: the supposed financial safety net may be millions too small. This is where the courtroom drama turns into a financial nightmare, because the numbers being repeated publicly do not tell the entire story. Behind the sensational estimates sits a smaller figure with potentially devastating consequences, and once that number is examined, the illusion of protection begins to crack.
Bazillion-dollar case against the Daily Mail lost on all 97 counts, and now it seems like he kind of knew. This seems like they're in a lot of hot water, but also the judge, Justice Nicklin, is furious.
$30 million from Diana, gone.
And you know that you've got him on the hook here. You really have put him on the hook and squirming. The potential embarrassment of the discovery process is nuclear. It really is.
Worse, they all wind up in bankruptcy.
Prince Harry's court cost ruling is expected this month, but there's a major twist. The number dominating the headlines may not be the number that actually matters. You've heard 34 million. You've heard 50 million. Those figures have been thrown around everywhere, but the number to watch is 16.2. Remember that. 16.2, not 34, not 50. Because once we break down what that figure represents, this whole legal battle starts looking very different. That warning changes everything, because 16.2 million is not another exaggerated prediction being thrown around for attention. It represents the combined after the event insurance reportedly held by the 7 claimants, the protection intended to absorb the financial impact if the litigation failed. But protection only works when it is large enough. And according to written submissions presented by the claimant's own side, there is a possible outcome in which this insurance would not cover the total exposure. Suddenly, the safety net looks less like solid ground and more like fabric already stretching toward its breaking point. The disaster began with 97 claims, an enormous legal assault that promised accountability, vindication, and explosive revelations. Instead, the judgment delivered the exact opposite. Every claim was dismissed, not reduced, not partially accepted. Dismissed, that crushing outcome immediately transformed the battle from accusations against the publisher into a terrifying argument over who must pay for everything.
Brought that bazillion-dollar case against the Daily Mail, lost on all 97 counts, and now it seems like he kind of knew his witness was horrific and bad news 4 years ago. Tom, what is going on?
97 claims, and according to the judgment, every single one was dismissed. On July 7th, Justice Nicklin delivered a massive 436-page ruling against the Duke of Sussex and 6 co-claimants. This wasn't a partial win, a technical split, or a situation where the court simply trimmed the damages. The claims were dismissed, making the cause question the next major battleground. And what a battleground it became. The publisher reportedly submitted costs exceeding $34 million, an amount so extraordinary that Mr. Justice Nicklin described it as unprecedented for a high court media law case. That description was not meaningless courtroom decoration. It was a flashing warning that the cost dispute had become a scandal within the scandal. Yet $34 million is still only a demand, not the final amount ordered, and the court can dramatically reduce claimed expenses during a detailed assessment. That uncertainty may sound reassuring, but another demand threatens to bring the pressure forward before the final calculation is even completed.
What do I expect to happen? I don't think the Mail will get the whole 34.5 million, but I don't think they'll be stuck with the approved costs either. I think it'd be somewhere in between.
Picked apart line by line, there's another issue on the table, an interim payment. That means money could potentially have to be handed over before the detailed cost assessment is even finished. The publisher has reportedly requested more than $9.9 million as an interim payment shared among the 7 claimants. Think about the timing. Before every invoice is challenged, before the complete assessment is finished, and before the final financial damage becomes clear, millions could potentially be demanded up front. The claimant's barrister has branded that request excessive to the point of being unjustifiable, but the final decision does not belong to either side. It belongs to the judge, with a written ruling expected around the week of August 17. Then, the mystery returns to $16.2 million. The 7 claimants entered the 11-week trial with combined 8 insurance reportedly totaling that amount. On the surface, it looks enormous. Against the publisher's claim costs, however, it suddenly looks dangerously limited. Even more alarming, counsel for the claimants reportedly ignored acknowledged in writing that if costs were awarded on the indemnity basis, the current cover would be insufficient to meet the total exposure, possibly by many millions of pounds. That was not whispered by an anonymous enemy. It was not invented by a hostile commentator. It reportedly came from their own legal submissions, and those two words, indemnity basis, could decide whether this remains a painful defeat or erupts into something financially catastrophic. Under the standard basis, costs must generally be reasonable and proportionate, allowing disputed bills to be cut substantially. Indemnity assessment is harsher, removing much of that protection and resolving doubts more favorably toward the receiving party. The insurance exists, but it has a ceiling. The demanded costs may rise beyond it. Somewhere between those two figures sits the potential shortfall, waiting for one judicial decision to expose it. Then came the statement that could transform a devastating loss into an even more punishing financial catastrophe. After the judgment, the outcome was branded a complete and obvious whitewash, with Prince Harry and Baroness Lawrence attaching their names to that extraordinary accusation. But the silence of the others became an explosive clue. Why would 5 people who fought through the same case suddenly refuse to stand beside that statement? Whatever happened behind the scenes, the visible split handed the publisher another weapon.
Statement is being used by the Daily Mail. They are saying that the statement sort of shows the bad faith of 2 of the claimants, Harry and Doreen Lawrence, who put their name to that statement. It's interesting that the other 5 didn't put their name to it.
And this is where things get even more heated. After the judgment was handed down, a statement was issued describing the outcome as a complete and obvious whitewash. Prince Harry's name appeared on that statement alongside Baroness Lawrence, but the other 5 claimants did not sign it, and that detail has now become part of the wider costs fight. Elton John didn't sign it. David Furnish didn't sign it. Sadie Frost didn't sign it. Liz Hurley didn't sign it. Simon Hughes didn't sign it. That unmistakable divide is now being cited by the publisher's lawyers while they argue for indemnity costs. The very outcome the claimants' own submissions warned could push their exposure beyond the $16.2 million insurance cover. A statement meant to express fury may therefore become part of the argument for a harsher bill. One reaction, one collection of signatures, one potentially enormous consequence. For roughly 6 years, Prince Harry has repeatedly argued that security concerns surrounding him and his family are serious. Those concerns have appeared in court proceedings, public interviews, and his memoir, and they have also played a major role in his separate legal battles over security arrangements in Britain. Yet after the ruling, senior judicial figures reportedly warned that the complete and obvious whitewash statement risked threatening the judge's safety. The contradiction is impossible to miss. Security has remained central to Prince Harry's public case, from his litigation involving Ravik to his explanations for keeping his family away from Britain. But now criticism is focused on whether words carrying his name created a danger for somebody else. The court must decide what matters legally, but publicly the optics are brutal. Responsibility cannot simply be pushed toward another claimant because the cost dispute involves shared liability and a global interim payment demand. One allegation involving Chelsea Davy may reportedly have possessed stronger prospects as an individual claim, but it was included inside the larger package of 97 dismissed claims. There is no clean personal invoice waiting at the bottom of the judgment. Only 7 claimants confronting one complicated financial reckoning. Could the bill simply be paid? That question becomes darker beside reports of enormous Montecito expenses, allegedly reaching approximately $6 million annually before lifestyle spending and travel. Commentary has claimed inherited money from Diana and the Queen Mother has already disappeared, while private security, staff, clothing, and daily presentation continue consuming extraordinary amounts. Meghan reportedly faces declining American traffic around her business, even as overall website visits create the appearance of growth. A product once criticized for being excessively expensive has now been followed by a candle set costing $262, exposing another awkward contradiction between an earlier public image and the present commercial reality. Meanwhile, the royal foundation connected to Prince William and Princess Catherine has reportedly overtaken ArcuWell in American charitable momentum, striking directly at the market with a Sussex operation intended to become dominant. The money looks tighter, the audience looks shaky, stickier and the legal pressure is multiplying. Another defamation action involving Santabale and Mark Dyer raises unanswered questions about funding because the charity is reportedly not paying for it. Speculation about a hidden financial backer remains unproven, but disclosure could become the real danger, potentially opening relevant private communications involving Meghan Markle. The Charity Commission previously found no evidence supporting the central bullying allegation, yet the litigation continued. That leaves two cases, potentially enormous bills, and the possibility of private messages entering a formal legal process. King Charles may still permit limited family contact, but commentators insist no working royal return is waiting. William appears unwilling to reopen that door, and reconciliation without institutional restoration offers no guaranteed financial rescue. Nothing is settled until the costs ruling arrives. The $34 million demand may be slashed, indemnity costs may be rejected, and the $9.9 million interim request may be reduced. But one warning remains in writing: $16.2 million might not cover the bill. And if the court agrees, the safety net everyone assumed would hold could tear apart at the exact moment another courtroom begins pulling private secrets into the light.